So I've done a few posts. It's Monday, about 5 p.m. West Coast time. I've done a few videos over the last few days about how I firmly believe that Jonathan Ross, the ICE agent who put 3 bullets into the head of Renee Nicole Good last Wednesday, I firmly believe that he's going to be prosecuted by the state of Minnesota, by Hennepin County District Attorney. I think her name is Mary Moriarty, who's already opened an investigation. And they are in the stage right now of collecting and preserving what evidence they can get their hands on, which includes all the videos that we have all seen, the video from Agent Ross himself, and witness statements. I guarantee you they are interviewing witnesses like crazy right now. They will not have access to the vast majority of the physical evidence in the case, including the firearm used by Agent Ross and the vehicle that Renee Good was in when she was killed, because the feds are walling them off. And my comments have been flooded by non-lawyers telling me that I'm wrong, even though I was a trial attorney for 27 or 28 years. Did multiple jury trials, which, I mean, that's just part of the gig on social media, especially on TikTok. People who can't spell and barely have a grasp on the English language, who I assume graduated from high school, but clearly didn't go to college and definitely did not go to law school, telling a seasoned veteran trial attorney that he doesn't understand the law. But, everybody keeps coming into my comments saying the supremacy clause, supremacy clause, supremacy clause. I mean, you hear terms like supremacy clause and double jeopardy when, let's take the case of Derek Chauvin, the police officer who killed George Floyd. It's almost 6 years ago. He was prosecuted by the state, but then the feds came in and prosecuted him as well. And you saw the same group of people saying, screaming double jeopardy, things like that. Well, the government prosecuted him for civil rights violations, different charges than murder. And, concerns about that kind of an overlapping prosecution. My main point is the following. Those questions like double jeopardy and supremacy clause come into play when the government is actually going to prosecute someone. The DOJ, in this case, is not going to prosecute Jonathan Ross for anything. They're not going to prosecute him. So there's no risk of double jeopardy. There is no risk of overlapping or duplicative criminal charges in this case. They are not going to prosecute him for anything. In that circumstance, which I don't know that this has ever been tested before, frankly, when you have someone who shoots another person in the head and the federal government prosecutes that person for that crime, then these issues are relevant, they're salient. When the government announces that they are not going to prosecute him at all, because according to the government, the woman who was killed is a domestic terrorist and the shooting was justified, if they're not going to prosecute him at all, there is no danger of supremacy, there is no danger of duplicative charges, there is no danger of double jeopardy. So the question becomes, can the government dictate to a locality, Hennepin County in Minnesota, and the district attorney of Hennepin County, can the government dictate, yes, a resident of your city shot and killed another resident of your city, but we are dictating to you that you are not permitted to prosecute that person because they were on the job as a federal ICE agent. ICE, who has absolutely no jurisdiction over American citizens. Their jurisdiction is immigrants and customs enforcement. And I think the answer to that question is no. The government does not have the power to prevent a locality from prosecuting an alleged murder that took place in their jurisdiction involving two residents of that jurisdiction. No one has provided me with any kind of proof that the government gets to prevent that kind of a prosecution when the government is not going to prosecute that person for anything themselves. But, you know, what do I know? Social media is so much fucking fun, man. I was DMing back and forth with my buddy Brino DC yesterday. He was getting a lot of these same comments on some of his videos, and you know, and he was like, "Yeah, at first I got fucking angry, but then I was like, who gives a shit? These people don't know what they're talking about. Who cares?" It's just, you know, we're so polarized in this country right now. We're so incredibly polarized. You know, you got the Charlie Kirk fans cheering on this woman's killing, cheering it on, congratulating the ICE officer, saying that we need more of this after they coordinated nationwide, very well organized campaigns to get people fired from their jobs for saying mean things about Charlie Kirk after he was killed, such as, you know, things like Charlie Kirk was racist. Charlie Kirk was a misogynist. Charlie Kirk was a bigot. Charlie Kirk was homophobic. Charlie Kirk was transphobic. And there were allegations after his death that he had some connections to the trans community somewhere in the United States. You know, and then I guess Grindr experienced another overload in the Phoenix area on the day of Charlie Kirk's funeral, which I'm sure is purely coincidental. But man, white MAGA men who love Donald Trump sure seem to also love dick and trans women. Just, you know, not out in the open, but yeah. But again, the question is, can the federal government prevent a county district attorney from prosecuting a murder of one of their citizens by another one of their citizens when the federal government is not going to prosecute that person at all? And I firmly believe the answer to that question is no. And nobody has proven me wrong. Certainly not the army of Facebook and Google lawyers in my comments. So, hope that helps.